this panel, while we are, I think Isaac is going to get Anup online with us. He's an attorney on the West Coast, and you'll hear more about him. They're going to tell you more about the policy side of, because it's very important that we have people in all of these roles, because if the persons making the policies that govern this technology don't understand diversity, as they mentioned, you can have some biases in some of these applications, these technologies, these machine learning data models. And so we want, our goal is to infuse all of the pipeline with diversity. And so without further ado, looks like you guys are there. I'll let you take it away.
We don't need to be mic'd or anything. We're
good.
Excellent. Hi, good morning, everybody. I'm Natalie Roisman. I'm the executive director of the Georgetown Law Institute for Technology, Law, and Policy, or we call it the Tech Institute. Excellent. Hoya?
Yes.
Wonderful. We love Hoyas, and also everybody else. So I'm really delighted and honored to be here this morning talking about the impact of data privacy and security on society and the practice of law. Really appreciate it being teed up in terms of the policy question, but I do want to just say one thing about that before we kick it off, which is there's some people who will say, well, sort of here's legal over here, here's policy over here. And I think what you'll hear from this panel, as well as with practitioners generally when you chat with them, is that those silos are really not so clear. It all goes together. And so if you work for a company and you're trying to figure out what you need to do to comply, but you don't like what you need to do to comply, then you try to change the policy. Right, so we'll try to give you a flavor for how these things blend together. I could introduce all of our wonderful panelists, but I would actually rather that they do that themselves. They can give you a real flavor of what their career paths have been and what they're doing now and what keeps them up at night, all sorts of things like that. Loyaan, you want to kick us off?
Sure. Thank you, Natalie. Very, very happy to be here. Actually see my classmate from Howard Law School over there, Devin Grant. So it's great to be here and to talk about this really important subject. I'm Loyaan Egal. I am the Chief of Enforcement at the Federal Communications Commission, so otherwise known as the FCC. So, you know, when I'm not up at night worried about Super Bowl halftime performances or what's going to be said at an award show, I deal with enforcing, leading the Enforcement Bureau, which is basically the largest unit organization in the FCC, responsible for enforcing the Communications Act of 1934, which is amended through the Telecommunications Act of 1996 and a bunch of other times it's been amended, and the rules and regulations that the FCC sets forth. So that is the primary responsibility of the Enforcement Bureau. We work with the other, what we call rulemaking bureaus and offices in the FCC to work with them with regards to making sure that we can provide assistance as they write rules and engage enact policies, and we can assist from what we've seen from an enforcement investigative perspective. Before that, I was at the Department of Justice at the National Security Division, running what's known as Team Telecom. That's the colloquial name of it. It was a foreign investment screening mechanism interagency group made up of DOJ, DHS, and DOD. With a bunch of other agencies where we screened foreign investment or ownership in U.S. telecommunications infrastructure. And before that, I was at the U.S. Attorney's offices, both in the Southern District of New York and the District of Columbia, where I was a federal prosecutor, doing a whole range of things from bank fraud, wire fraud, FCPA, to international narcotics trafficking and money laundering. So I've kind of run the gamut on the public side.
Thank you. And now, Anup, can you hear us okay?
Yeah.
Terrific.
Am I coming through? Yeah.
Yep, we can hear you just fine. Thanks. Tell us a little bit about what you're doing, what your career path has been, and what keeps you up at night when it comes to privacy.
Sure. My name's Anup Suresh. Glad to be here. I'm a principal and registered patent attorney at Schwegman, Lundberg, and Woessner. It's a national intellectual property firm. My practice focuses on patents and procuring patents, specific in technologies, electrical engineering, and software technologies. But I also serve as the data security officer for our firm. So that means I switch hats a lot, handling privacy and data security issues and policies that come up for the firm. My general day-to-day work as a result of that is just switching back and forth between doing my patent practice and dealing with all these issues and that might arise. Before this, I was at a big law firm and I was in-house for quite a few years. And before that, I was actually engineer at Boeing for a little while before I actually started practicing law.
Great, thanks. And last but definitely not least, Adonne.
Just learned that I can now launch a complaint against the complaints from the Super Bowl to my colleague. So my name is Adonne Washington. I'm a Howard Law alum. I graduated in 2020. I am currently policy counsel at the Future of Privacy Forum. My focus is mobility, data, and location. While before that, I was at the Lawyers Committee for Civil Rights Under Law, working on their digital justice initiative, where I actually covered kind of everything that you would think of when you hear digital. So we focused on all things privacy and data, in addition to content moderation, more privacy legislation, and hate and disinformation online. And so that's kind of just where I navigated from working more on the civil rights and the actual legal aspects of the digital and privacy, and now moved specifically to focusing on privacy. I'll just say what keeps me up at night most recently, while not particularly related to my job, is Section 230 is actually what's been keeping me up at night. So I'm looking forward to this panel, and I'll pass it back to you.
Great. Well, I'm going to actually pass it right back to you and say, you mentioned you work on sort of all things privacy and data. And I think we use a lot of different terms, and some of us are just not really sure what the differences and similarities and overlaps are. So can you talk a little bit about privacy, data security, cybersecurity, and anything else involving any of those words that isn't covered in that? How are they the same? How are they different?
Sure. I actually love that question when I saw that, because I think we do talk about a lot of them, and oftentimes they get conflated between the three of them and confused, or things are just kind of lumped together as opposed to being separated out. So a bit on privacy, just think of privacy kind of in the actual context of keeping your information or things about yourself secure and private and free from interference or manipulation from others. And you're thinking about, when you read a organization's privacy policy, how they're going to ensure that the information that you share on that website is going to be maintained and kept safe. In terms of data security, we're thinking of the digital information safe from unauthorized access, corruption, and that's through the whole life cycle of that information that you're providing. And this could also be the physical device that the information is being kept on, so your hard drive, your jump drive, floppy disks at one point, and it is also on the virtual side, more data encryption, data masking, that sort of thing. When we're talking about cybersecurity, and this is not an area that I have an extensive amount of experience in, and so the distinction here is very important for my job. Cybersecurity is what we're thinking of when we think of hackers or someone getting into your device. And so think of the Norton antivirus software that you might put on your computer, helps to prevent from those sorts of attacks and those sorts of attacks and the sensitive information that lives on those devices. Privacy, information privacy, data privacy. Data privacy cannot exist without privacy. And so the data privacy is exactly as it sounds, keeping that sensitive information, the data points that are made and collected about you. This could also include biometric identifiers, all of that. The concept of privacy, or excuse me, data privacy encompasses that as well.
Thank you so much. That was extremely helpful. I'm going to add just one thing to the cyber point. I am, not very deep on cyber. So I just want to add this one point for folks who are trying to think about, well, which direction might I want to go career-wise, or what do I need to be concerned about? So yes, hackers and all of that, right? But even those you can sort of divide into different categories today, because we're looking at nation states that might actually launch some sort of attack relating to networks. And then we're also looking at, people who simply want to try to grab some sort of data or control of something that then they're going to hold in exchange for getting something else back. So while the protections against those two types of things might be the same, if that's an area of law that you're interested in, that's really sort of the universe of what you want to be concerned about. So that actually gives us a nice jumping off point, I think, Loyaan, to the national security issues. You come to the issues of privacy and security from a national security background. Now you're in an enforcement role at the FCC. What has that transition been like, for you? And how does that national security perspective affect the way that you look at the issues sitting at the FCC?
Yeah, so I spent 4 years running the team telecom process, and I refer to that as being FCC adjacent because we were national security agencies that were working with the FCC to assist the FCC in making determinations with regards to whether granting an FCC license was in the public interest, and in determining whether or not it's in the public interest, some of the factors to consider included national security, law enforcement risk. And so that was just every day of working with the interagency, trying to reach consensus because you'll be surprised there's not always agreement throughout the interagency.
I'm shocked to hear that.
Yeah. And then sometimes having to go all the way up to the White House to referee and make a decision on where things stand. Because on one hand you have national security agencies, on the other hand you have diplomatic agencies like the State Department. You have U.S. Trade Representative, you have Commerce, and they're thinking about this action that you're recommending to take against this foreign entity in the U.S. How is that going to impact U.S. companies overseas? So that was the lens through which I was looking at the telecommunications, information communications, technology issues. Now coming to the FCC from a regulatory enforcement standpoint, the FCC has through statutory authority and regulatory rules that it's enacted, specific protections with regards to what's called proprietary information or customer network proprietary information, referred to as CPNI. And in that instance, the service providers, mostly telecommunication providers, are responsible for protecting that information and keeping it confidential. And so when we initiate investigations with regards to as you described, we look at this from privacy, which is information that these entities have lawful access to, right? The companies that you interact with that provide services to you, they get your information. How are they treating that information with regards to your privacy? That's one bucket. The other bucket is how are they securing that information, right? And then the last bucket, to bring in the cybersecurity aspect of it, how are they protecting the networks in which that information is housed? And so sometimes you hit all three in an issue. Sometimes you hit one of three or two of three, but you have to look at all of those issues and see how they intertwine, how they intermix, and how they overlap. And so for us, there's what's called Section 222 of the Communications Act, which deals with the CPNI, but the FCC also has authority with regards to cable providers and with regards to satellite providers and making sure that those entities are protecting information as well. So, we work hand in hand in our instances, in our cases, with our partners, whether it's the Federal Trade Commission when we're investigating matters from a consumer protection standpoint, or with the state attorney generals. So there's a lot of coordination on that sense. To your question about how has my national security background influenced regulatory enforcement, it's made me tell my colleagues to focus on these issues, right? To focus on FCC enforcement issues that either directly or indirectly impact national security. So I'll give you an instance that doesn't necessarily touch on privacy per se, but when a company has an FCC license and it gets acquired by another company, it has to get the FCC's permission in order to transfer those licenses. So that transaction, so I'll give you an example. One was the Sprint T-Mobile merger. Because T-Mobile had significant foreign ownership with regards to Deutsche Telekom, and Sprint had significant foreign investment with SoftBank, those things went through a review, right? And those were sent over to Team Telecom for review. I can say publicly they were also reviewed by CFIUS, which is the Committee for Foreign Investment in the United States, because the companies publicly said they were under CFIUS review. And so we looked at that transaction, but they went about and got, they wanted to get the regulatory permissions before they effectuated that transaction. You have a lot of companies who effectuate transactions and don't get regulatory approval, right? And then And so for us, we want to be able to look at the ones that trigger, referrals to Team Telecom for screening for national security law enforcement risk. We've done an emphasis to say, we're going to enforce those violations because those touch on national security and law enforcement risk. So that's an example.
Great. Well, I have a bias, which is that I practiced before the FCC for many years and also worked at the FCC. So I particularly appreciate the examples and wanted to just underscore that you've pointed out that somebody could have a career in M&A work, deal work, sort of corporate transactions, and still also touch on these issues of privacy and security, because if you're acquiring a company or if your company is being acquired or you're representing either of those parties, you do have these issues that come into play.
No, that's exactly right, because understanding how transactions are set up, these are very complicated deals. There's investment that you have to, layers and layers of investment to get through to see who actually is part of this transaction so that they could be vetted. And so that's the M&A, the transactional side of it. You have the litigation side, because as you're doing these assessments and you make a recommendation, if you're in Team Telecom or the FCC accepts that recommendation and makes a decision based on that recommendation, you have to assess litigation risk, right? Because those companies, many of them are deep-pocketed, some who might be state-owned enterprises, they're going to litigate. And there's plenty of law firms willing to represent them on those issues. So you have to think through the litigation risk issue throughout the process.
Adonne, I know that in your role at Future of Privacy Forum, part of what you do is you help the companies who are part of FPF figure out how to navigate certain things that are going on now, what might come down the road in the future. You have a specific focus on data with respect to mobility and location. So what are some of the unique considerations in those areas, and how are you talking with others about what they should be aware of and what they might anticipate?
Sure. So mobility, as you might have guessed, does encompass cars, and encompasses kind of anything that moves and anything that relates to technology in that context. So for the purpose of providing an example and a better understanding of the question that Natalie just asked me, in the car space, we're currently thinking about all of the different types of technologies that are going to be and are already being incorporated into vehicles. We think of our cars, as a means to get from point A to point B. And at one point, that was truly what the purpose of a car was. And now we are really seeing a lot more under the guise of convenience and safety, different features that are being put into vehicles, cameras. There's Alexa capabilities in some vehicles. Other companies have developed their own voice recognition and kind of other automated decision-making style algorithms into vehicles to do many different things. And I think one of the other ones that I'm missing is the location and mapping capabilities that your car offers you. Obviously, being in DC, we definitely need those features to get anywhere on time or in a decent path. And so we're thinking about all of the ways that these different technologies are being incorporated, be it by the OEMs, so the manufacturers of the cars, but a lot of them are also using third party. So in that context, the data and privacy kind of gets, thrown around. Some of it is owned by the manufacturer. Some of it ends up going through to those third parties that are inputting your Apple CarPlay or the Android services into the vehicles. And so we're constantly thinking about how are all of these different data points that your car is collecting, where is that information going? How is it being stored? How is it being collected? Is it being transmitted off the vehicle? And so forth. When we are talking to our members and those that are our stakeholders, members of FPF, we are thinking about legislation a lot recently, and the way that the different state laws are impacting how all of these different data points that the car is collecting and all these different uses of technology are going to need to fluctuate based on the different state laws. Illinois has the the Biometric Information Privacy Act. And so that is one of the only states with a comprehensive law that allows an individual to bring a private action for their biometrics. Biometrics meaning your fingerprint or your facial recognition scan or even your eyeballs. And so in Illinois, you have those specific biometric protections that you might not have if we're going to go to, let's say, just a state over in Indiana. And so talking with our members about how the legislation could impact them when they're selling cars to these different places is one of the things that we're often thinking about. Outside of the car space, FPF is also just thinking about the legislation in similar ways for our other work streams. So we have a range of members. Obviously, I deal with a lot of the manufacturers and others who create technology for vehicles, but we also have other stakeholders in academia, other organizations and companies as well. And so constantly tracking legislation and updates in the world of privacy, both in the US and globally, for how to handle the updates and the changes. The fact that different states have different laws means that even though the car is doing the same thing in Michigan, Indiana, and Illinois, those data privacy kind of concerns and protections might fluctuate between the states.
I can definitely relate to that because I have a son who's 15 and a half, and he has been informed that he will have no privacy while driving my car. So we are thinking about a lot of those same issues, maybe slightly different perspective, because I'm all for the no privacy in this instance. So Anup, we did not forget about you in a different time zone. Hello. I think you bring a really interesting perspective to this conversation because a lot of times we have panels that talk about, and what should this policy be? And what should this policy be? And we don't really, talk with people whose responsibility, especially for smaller businesses, is to follow whatever the policy is. So you're an IP lawyer, you said, patent lawyer, but for purposes of this privacy and security discussion, the issue is not that you counsel clients on those issues, because as I understand it, you don't, but that you're responsible for ensuring that your business is adequately protecting data and networks, both those of your firm as a business, as well as what clients give to you. So what does that look like for you day to day? And as a very practical matter, how do you keep up with changing laws and policies?
Yeah, sure. So day to day, I mean, when I'm not doing the patent work, which is majority of my work, it's handling client requests and basically dealing with survey requests or security requests that they may have. And if we have incidents, basically investigating those and coordinating with like our IT director and other management personnel in dealing with these issues. It might involve internal policy development or updates that we need to do in order to meet the requirements that the client is kind of prescribing upon us, and educating our firm personnel on our actual policies and practices in securing data and the privacy of the information that we kind of collect from our inventors. So it's a lot of coordination for the most part, and basically dealing with issues from day to day or week to week that come up. In terms of keeping up with it, we really rely on the expert outside. So we do have legal experts that we consult with. We do have policy experts that are well versed in actually developing policy, in particular for like law firms. And we do rely heavily on our data security, the actual vendors that put in the security tools. They're very well versed in the policies and what we need from an infrastructure standpoint, even from a practice standpoint of what we need to be implementing on our end to keep updated. And of course, I try to keep up with it as much as I can, holding the two dual roles, but there's definitely a lot to learn. There's always a lot changing. So we really rely on those experts.
Thank you. A great example of how somebody can be an attorney who's responsible for privacy and security issues in a lot of really different ways. I'm glad that you bring that perspective. Let's talk for a minute, though, about sort of big picture privacy policy, federal policy. Yesterday was the most recent hearing on a federal privacy bill. There have been a lot of them over the years, probably more than any of us can count or care to remember. There's no comprehensive federal consumer data privacy law in the United States. Sometimes you hear people sort of shorthand say, the US has no federal privacy law. So it was a sense, Adonne, of, is that accurate? Do we have no federal privacy laws? What do we have? Where are there gaps? And, what do you think some of the obligations are that exist today, and where might this be going?
Sure. It's to say blanket statement that there is no federal privacy law is not a wholly accurate statement. I think that's one of the things you want to get at. And so there are different laws that have come into effect that do handle privacy. One of the most specific that does handle privacy and covers it is COPPA, and it's the Children's Online Privacy Protection Act. And so COPPA is kind of one of the examples of a true sort of privacy law that does exist. We also have other laws and regulations that do get at aspects of privacy and cover kinds of handling of data and so forth. And I think the gap really comes in because we don't have a comprehensive federal privacy law. So comprehensive meaning covering all of the aspects as what we understand and see technology today for all people. And so the gaps, and I kind of mentioned it before, come in with the patchwork that we are seeing in states. So California has their Privacy Act. Like I mentioned, Illinois has a biometric version. One of the things this year, and I say this to anyone who has an interest in this space, we have seen many states start to introduce their versions of data privacy acts there are some specific to cybersecurity, some specific to biometric information, and then some running the gambit of what they cover. And so it's great to see that states are trying to provide these protections for their individuals because they're realizing that jumping from state to state, or in certain instances, these protections are becoming a lot more necessary, especially as Americans are starting to pay more attention to how their data privacy and information is being used and transmitted. So we see that gap. One of the key obligations, I would say, would be transparency, and that is kind of one of the issues that we run into working in policy, is being able to understand where companies are using this information, how they're using this information. And so kind of we look to companies to try and start with the transparency, and that provides a bit more understanding for those that are trying to provide, like us, best practices or best ways to abide, or best ways to protect consumers' information, data, and privacy. I'd say one of the other things to understand, and I think is a key obligation at this point, would be opt-in and opt-out consent for actually having these, when you go to a website, putting in your information. Do you opt in to having this information shared, and understanding that while that puts a lot of onus on the actual consumer and on the individual, and I do not think is a solid, straightforward way to kind of do away or to protect privacy, that is a necessary obligation and function that we are seeing across the board, providing these kind of clear and transparent understanding of privacy policies and what you're opting into and how that information is being used. In the post-Roe world, one of the aspects of what I work on is location as well. And so when we started counseling, counseling is the wrong word, we started discussing with our members and having conversations about potentially what could they do to ensure that they are taking the highest, taking their consumers' data and information with the utmost care, was kind of how do you best protect this information, and what can they do internally, even if there is no federal privacy legislation, or if they are dealing with a patchwork of states. So ensuring that they have a better understanding of what they can do even without some of that federal privacy legislation.
Gives us a good segue, I think, to the next question that I know is going to be informed not just by the work that you're currently doing, but by the fact that you were at the Lawyers Committee before that. It's a very interesting time in privacy law and policy, because a lot of government agencies at the federal level are finally having these really important conversations about what are some unique harms to communities of color in terms of data collection, commercial surveillance, et cetera. For a while, people have been very aware, you talk about law enforcement surveillance, there are particular risks there. Now we're looking, outside of the law enforcement context and into, frankly, what are companies collecting? What are some of the unique risks there? What do we need to be aware of? And just as a few examples, so NTIA, which is part of the Department of Commerce, currently has a proceeding with comments due next week that's looking into discriminatory disparities in the digital economy and the extent to which the collection, processing, sharing, and use of data leads to higher risks for some communities and might exacerbate inequities. The FTC has asked for comment about commercial surveillance and data security. The FCC has an open proceeding, not quite focused on the privacy issues, but generally on digital discrimination issues. So all of these conversations are happening, at the same time. What do you think is the best way for policymakers to bring, a meaningful equity and inclusion lens to their efforts, and what should they really be focused on?
Sure. I think the focus should definitely be on, and I believe the last panel mentioned it as well, ensuring that, and Charlie has mentioned that kind of at the beginning of the panel, ensuring that the people that are in these vulnerable communities, marginalized populations, or have been subjected to historical discriminatory impacts are in the room. And having the conversations and understanding. And so they may not be in the room necessarily as the policymaker, but meaningful engagement with these communities. And I don't just mean just going into the community asking a local, trying to think, and I'm now moved from Michigan and so forth, but asking like a local chapter of Black Lives Matter to potentially join in and sit in on a panel or in a conversation or into a room or stakeholder roundtable, and having them just be there, right? It's more about having them truly engage in the conversation, providing them, and maybe Black Lives Matter was the wrong analogy here, but a local organization that handles these different kinds of communities, asking them and actually providing them the tools to understand what is being discussed in that room. What is the conversation? When we say privacy, what does that even mean? And providing even some of the basic and kind of foundational understanding for the issues that we're discussing so that they can not only advocate in their communities and on behalf of those that they represent, but also they can engage more meaningfully in conversation with the policymakers and with the legislatures in the different spaces. So ensuring that the voices in the room making these decisions and having these conversations are representative of the people who are most likely to be impacted. And I would actually love to hear Loyann's I know we kind of talked about briefly FCC's proceeding, but I'm kind of curious just in terms of enforcement and how that goes. We call constantly for policymakers and federal agencies to work on these different issues and to handle these different matters. But I think it'd be helpful to understand when we say that, how does that actually work internally, and how would that actually go if there was some sort of mechanism to actually deal with discrimination and kind of this influx of data and information that could have bias and discriminatory impacts.
So I will start with the digital discrimination part of it to say, there's currently a rulemaking going on at the FCC, so I won't comment on that. But once that rule is finalized, then it will fall on me to enforce it. But related to that, the under the leadership of Chairwoman Jessica Rosenworcel at the FCC, the commission has created a digital discrimination task force to look at these issues, to do outreach to the communities, to discuss these issues. She's recharted the Communications Equity and Diversity Council. And in addition to that, and here's where you talk about equity and kind of knowing how things work in Washington. With every rulemaking, the commission now requires requesting comments on how the rule is going to impact diversity, equity, inclusion, accessibility. So that is an opportunity, regardless of what the rulemaking that's being discussed, for people to kind of provide their input into, how that potentially may impact those issues. To your question about like enforcing, I thought about, you mentioned location, right? And so back in 2020, the FCC, and this was before I came back to the FCC, I was still at DOJ, the FCC put out an enforcement action under what's called a notice of apparent liability. That's the equivalent of a complaint, or in the criminal sense, an indictment against the four major wireless communication providers with regards to how they were treating location data. right? And how they were, you know, based on the investigation, the allegations being that they were selling it to aggregators, who then were selling it to third parties, who were using it, you know, in one instance, you know, the New York Times wrote an article about you know, a sheriff who got arrested because he was using it to track down his colleagues or judges. So that's an example where you know, enforcement can shed a light on a practice that touches on privacy, right? And the other aspect of it too is just last year, the chairwoman issued a letter to 15 of the largest wireless carriers seeking information with regards to how they were collecting, retaining, treating geolocation data. And she publicly announced, so I can say that you know, the commission was going to be investigating that. So those are very particular ways in which, you know, enforcement can be used to get under the hood, for lack of a better term, to kind of see what's going on with industry. And to bring it back to the digital discrimination, as I said, I think understanding how rulemakings happen, how rules are enacted, rules that you know, interpret congressional statutory authority. I think it's critical for people to understand that, see how that's going to impact.
No, that I was actually going to throw it to him after that. So really it was perfect and you did that. I did have a quick follow-up in it. It's not something we discussed before, so
Okay.
feel free to say you're not going to talk about it. But you've talked about some of the things where the FCC has pursued inquiry or enforcement in terms of privacy related issues regarding certain types of entities. And we may have some people who are participating today who aren't really familiar with the distinction between, well, why does the FCC have that authority over certain types of companies or services and not others? Do you mind talking for a minute or two about where those lines are drawn?
Yeah, so you know, I think when people think about these issues, you know, the FCC doesn't necessarily come top of mind, right? People think Federal Trade Commission, they think of DOJ, and I think it's also good to kind of understand, you know, just because you're the U.S. government, it's not a monolith. You know, people have different equities. So, you know, for instance, if DOJ is investigating an issue, they're going to want cooperation from the company, right? They're going to want the company to tell them what happened as soon as possible, so that they can, FBI and whoever else can start doing, you know, the necessary evaluations, right? Maybe determine is it a state actor, is it a criminal enterprise? The regulatory, you know, folks like me, you know, we're looking like, did you comply with the rules? Yeah, this is bad that this happened to you, but were you doing what you were supposed to do, right? And that's a different posture for a company than, you know, yeah, give us everything, and you know, we'll look, you know, we won't. We're trying to get the bad guys, so we're focused on the bad guys. We're looking at, yeah, we're looking at the bad guys, but what did you do? And so distinguishing between, you know, the different agencies and their roles, the FCC is the sector specific agency with regards to regulations of communication services, right? So if you're providing telecommunication services, if you're providing broadcast services, satellite services, that is going to be in the FCC's ambit. The FTC is a general enforcer or general regulatory agency, right? So they will look across the spectrum at different things. And sometimes those things might touch on, you know, telecommunications matters. Now, there are certain things that they can't look at, for instance, with regards to common carrier services. Common carrier is kind of the theme. If you're a common carrier, meaning you're providing common service, you're providing the ability for person A to speak to person B, you know, you're the common carrier of this traffic. That is the FCC's, you know, domain. But the FTC kind of looks more at the marketing, the truthfulness, you know, the transparency. The FCC also looks at that as well. The other way that we're able to kind of work together and figure out how to do these things is we have MOUs, memorandums of understandings that we enter into, and we have one with the FTC. So we work closely with them on these issues. And I think that is something that has evolved, where before it was, you know, very territorial and everybody was kind of fighting for their own specific space. You know, it's now more coordinated, more holistic, more bring whole of government effort. And part of that is because the technology, I think the understanding of the technology, you know, there's a huge gap between, you know, what's in the private sector and where the government is. So being able to kind of pool resources and get smart on this, I think people have come to that conclusion. That's the best way to approach this.
Loyaan and Anup, we had a really interesting discussion about the distinctions between privacy, security, and the relative risks and vulnerabilities when it comes to company size, right? When it comes to somebody who is collecting our personal data, I think on the whole, we are generally much more concerned about larger companies, the scale they have, and what might happen with that data. Not so necessarily with security. And Loyaan, you had a really interesting take on this, and love for you to share that.
Sure. So this comes from my national security aspect, which is we're focused on supply chain, right? Because as you assess national security risk, it's kind of a formula that the national security intelligence community uses, which is threat, vulnerability, consequence, right? And the threat goes to intent and capability. Can a threat actor exploit a vulnerability? If so, what is the consequence of that action? And so we focused, the government at the time came together and said, yeah, we have these big companies, these big telecommunications, or what's also known as ICTS, Information Communications Technology Services companies, which I'll put into, the Googles and the Microsofts in that category, the hyperscale companies. What do we know about supply chain? Because, that's a vulnerability, and these are global supply chains we're talking about. So, when I look, first of all, the FCC, we look at, we have jurisdiction over the companies that have FCC licenses or authorizations. But as we're conducting those investigations, one thing that, I brought over is going, layers beyond just the company, but looking at the supply chain and looking at how the companies that we regulate, that are required to comply with the rules, how are they making sure that the supply chain third-party vendors that they're using are also complying with those rules. And that's part of our assessment when we do our investigation. So we're looking at the small companies, not necessarily from, how are they impacted, but necessarily how do they impact the bigger companies.
Anup, do you pick that up from the perspective of someone who's responsible for security at a smaller entity, and do you think it's fair to consider that you might be the weakest link, so to speak? Any reaction to that?
Yeah, I mean, to some extent that may be the case, but I believe it just flexibility and what we're obligated to comply with actually really just depends on the type of business. I think client service businesses really what they comply with really just depends on the clients that they're servicing. So like our law firm, we may be considered a small business or a small business entity, but the flexibility is almost like non-existent because the clients that we service are not small businesses, or they're in the type of business business that's like regulated by the FTC or some other government body. And so their compliance with their own respective regulations that they're obligated to comply with naturally results in them passing down security guidelines and requirements that we have to maintain and meet in order to keep servicing them. And in fact, our larger clients tend to send us surveys and audit requests on an annual basis to make sure that we're keeping up with their guidelines, which are constantly changing, as well as that they're driven by policy updates at the higher levels. And then that's constantly trickling down to updates that we have to keep on our end, internal policies, even the technology infrastructure, the costs of securing their data. In our case, in patents, we collect employee data, inventor information, and that's basically stored on our systems, and we have to meet their requirements as to the privacy and data security requirements that they have on their end. They might have international exposure. They might have individuals that are in the European nations, and so GDPR plays a part in the information that we have to handle with respect to the European employees. So we might be small, but the obligation still exists as if we were a larger company.
Great. Well, and I'm delighted that you mentioned GDPR there, because we've touched throughout this conversation in a few different ways, Loyaan, particularly from your background, global supply chain, team telecom work, and now Anup, you mentioned GDPR. Privacy issues, security issues don't stop at national boundaries because data doesn't stop at national boundaries. So really all of this is inherently a global question. Um, a lot of times when it comes to the regulatory space, we think, okay, well, the US will lead and then the rest of the world is going to follow whatever the trend is, in the United States regarding a particular legal regime. That doesn't really seem to be true when it comes to privacy, at least. There are multiple regions that may be well ahead of the US in that regard. So I'd love to hear from really each of the three of you. How do you see countries and regions outside of the US leading on privacy and security? And do you think that that's likely to continue? Kick us
Sure.
off.
I think the biggest thing that we see from outside countries is that they are actually um, passing nationwide and across their countries, the types of legislation that protect privacy for all individuals, privacy and data for all individuals. Aside from that, we do just really see. And I think the U.S. can learn a lot because we can see different countries who are enacting pieces of legislation that are very specific, and it also should serve as a kind of guidepost for different things that have worked well, because we've seen GDPR is now a few years old, and we've seen it gone into effect. And so, how do places actually enforce these different things? What does it look like in practice when it's actually working? And so I think the US can actually learn a lot from watching other countries implement this. I think the thing that really helps us with GDPR specifically is because, and as Anup mentioned, they have employees that are subject to GDPR. And so when states here have employees that are working in other countries that are subject to GDPR, they're starting to already implement some of the same kinds of prescriptive measures that they have to take to be in compliance with GDPR. And so I think what's beneficial here is that these other countries are starting to implement, and US obviously works with a lot of different countries, and a lot of US organizations, companies, individuals have ties to these other countries that have kind of these federal or these countrywide, statewide, nationwide privacy and data protections. And so because of that, a lot of companies have started to kind of already roll over and turn on the protections that are necessary to be in compliance with a lot of these other countries. So while we don't necessarily have anything, and in this instance, we are taking cues from other countries, it does still put us in a really good, the US in a really good position to understand what has worked, what might not work well here, and what the enforcement structure might actually look like when and if a federal privacy law does go into effect.
And there's such an interesting, I think, sort of subtext there, because philosophically, there's some major differences between the way that the United States has historically thought of, things like personal rights when it comes to privacy, and things that Europe thinks about. So, like the right to be forgotten, right? That's not a concept that we really have here in the US. But if we're taking the lead from Europe, then that is going to ultimately be bundled into where we land. Loyaan, thoughts on the
Yeah.
international
So
piece
I,
of
I
this?
won't I won't get into comparing who's in the lead nationwide with regards to privacy per se. I think you've spoken very eloquently about the different approaches. I will say, like, from a security standpoint, there are ways that the U.S. leads that many people don't even realize, right? So I mentioned, this foreign investment screening process, which now a lot of other countries are starting to pick up, because they've seen how the U.S. is able to screen transactions in a way to assess, is this transaction good for U.S. national security? And one way that's done an example of that is, for instance, when foreign companies or companies that have significant foreign investment or ownership want to provide telecommunication services in the United States, in, to, or from the United States, one of the questions that they have to be able to answer is, okay, you're going to generate U.S. records because there are going to be people in the United States using your service, or someone's going to be communicating from overseas to someone in the United States. How do you protect that information, especially if you're housing that information in foreign foreign countries, right? A lot of US information is housed in different countries by companies, right? So how are you going to protect that information? First, even assessing which countries are you housing that information in to the extent that those countries could present risk. So the US government has a way of assessing that, making records available, right? Not promoting data localization, right? Not saying you have to keep the records only in the United States, but how do you make those records accessible in the United States for law enforcement, national security investigations, right? So that if there's an investigation that could touch on public safety, human life, and it involves a foreign entity that has access to those records, making those records available in the US to take action. So I think that is a way that the US sort of leads and potentially touches into some of these privacy issues.
Anup, you were the one who mentioned GDPR. Any
Yeah.
further thoughts on what compliance with that has been like and? what
Yeah,
you
I think
might be
my
thinking?
panelists made some good points to cover that. But basically, I would only add that we may not be leading, but we're definitely catching up quickly. The state initiatives to create their own regulation. A primary example being California with the California Privacy Rights Act, which mirrors a lot of the provisions of the GDPR. What works, what doesn't work, has been really helpful. And California isn't the only state. It seems like a lot of the states are catching up. And so, as a natural effect, at least if we're not leading now, we definitely will be eventually, or at least catching up with our colleagues around the world. But an international exposure basically results in a lot of at least U.S. entities having to meet with those requirements as a natural effect of their business, anyways. So I'm not too overly concerned. If we can learn from others and what works and what doesn't work, I think that's great.
Great. I heard somebody comment recently that it seems likely that the US will go in the direction of Europe so long as we don't actually tell Congress that we're following what Europe has done. We have to repackage it as someone's brainchild here, and then everybody will think what a great plan. So things to think about. We have a few sort of career type questions left, but I did want to pause here and see if anybody has questions on any of the substantive privacy or security issues. Tell us who you are, please.
Hi, I'm Cameron Lynn. I'm a 1L from Howard University. Well, I was wondering, how do you guys respond to major data breaches, if you guys respond to that at all? And what are the policies that are in place now to prevent those, and just what policies are?
Loyaan, I bet you
Yeah.
love a data
Yes.
breach.
Yeah, there've been a few reported. So yes, I mentioned CP&I, which is customer proprietary network information that telecom providers, wireless providers are responsible for protecting. So whenever there is a breach, they have to report that to statute requires them to, and the regulation requires them to report it to the FBI, the Secret Service, within 7 business days of when they've discovered the breach. There's a lot of discussions happening around the government about, maybe, for instance, with CISA, which is the Cybersecurity Infrastructure Security Department of Homeland Security, has been designated as kind of the place to come up with where all breaches should be reported. So we'll see how that will work. But for us, when we become aware of a data breach, we begin our investigation, right? And we engage with the company. We put together questions to assess, what is the scope, the size, what information they currently have, and then it's a continuing process. One thing that puts the FCC at a disadvantage, as opposed to our colleagues, is unfortunately we have a 1-year statute of limitation to bring an enforcement action, right? And these are very complex cases and investigations, right? So unless we can come up with a theory that the harm is continuing, we have that 1-year clock. So we're on a much faster pace than some of our colleagues. And so we need to get in there as quickly as possible to assess and determine, was the breach a result of unreasonable practices, measures, could have been prevented? What is the harm that's involved? And how can we address that?
Anup, purely hypothetically speaking, because I'm sure that this has never happened with the data that you are charged with protecting, what would you do in the event of a breach?
We actually have policies and basically procedures on investigating those. So hypothetically speaking, this hasn't happened for us yet, but it's not always just our own breaches, it's our vendors as well. We rely on a lot of vendors. I mean, a number of us are exposed to using tools that are in the cloud. And so we have cloud vendors. If they have breaches, they report it to us. Investigation on our part is very important. We like many businesses have to carry cybersecurity insurance and so on. So our carriers themselves would want us to investigate whether, what happened, what the facts were, not necessarily who was at fault, but how things played out, just to figure out liability and whether they need to carry. We need to investigate further, or we get others involved or law enforcement involved. So we prepare for it at all times and constantly preparing for it. And we actually do have tabletop exercises in the event that these issues occur so that we can kind of hone in our practices as to how to deal with them as they come up.
Thanks. I think there was a question over here as well.
Hi everyone, my name is Abigail and I'm from Howard School of Law. Not too far off of what my colleague mentioned. My question is about this sort of lack of comprehensive federal legislation. So we see many, I guess, agencies that are catered directly towards this sort of fear of data breach and privacy. Do you think this is a workaround to the lack of comprehensive, like taking the eggshell approach, knowing that digital companies are a huge part of the American economy and you don't really want to step on these people's toes? But so that's my question. Do you think there's a fear of upsetting the industry or hindering the industry in any way? Or is it rather they just don't want to go up against any big dogs in any sort of unappealing fashion? And what do you think will take what do you think needs to happen in order for Congress to get on board to formulating this sort of closing that gap?
Sure. There were a couple of questions in your question.
Yeah.
And so I'm going to try and answer to the best of my ability how I think you move this question. But if not, I will be here after and we can chat more. So different federal agencies, we've actually seen some great strides kind of within the federal government and agencies specifically to try and handle data practices, policies, and procedures. FTC has done rulemaking, NTIA has their request for comment. We've seen CFPB, the Credit Financial Consumer. Thank you. Acronyms in the world of tech and policy are abundant, and they are not my strong suit all the time. Yes, correct. So the Consumer Financial Protection Bureau has also done a inquiry, and they're looking, and these agencies are trying to understand the implications for data, privacy, technology, cybersecurity, these different practices, and how they're actually playing out. So when we think about the FTC, they're looking at different, they are looking at those larger companies and kind of focused on, well, how are these companies and what they're doing impacting in all of these different instances when we talk about technology and so forth. When we look at CFPB, one of the requests for information that they did was related to artificial intelligence in the context of credit reporting and lending services. And so we see the agencies kind of doing more internal in their spaces and kind of what they have jurisdiction over to understand what this all means in their world. I don't necessarily think it's intentional to try and go around having a federal, but I do think we are starting to see the possibility and opportunity for a lot of these agencies to recognize, hey, we too would like some common framework to understand and to implement the automated decision making that might actually be efficient for their processing of, let's say, unemployment applications. And so the context, and I love looking at the different agencies to see what they're doing. They also have a lot of different statutes that sometimes bolster, bolster their ability to take action against discriminatory processes and procedures. Some people will interpret that in the context of privacy, to cover kind of the algorithms that can have those disparate impacts and so forth. So it at the federal government and within different agencies are doing things that kind of within their scope, just because it's the same concept of if you're looking at different states that have taken the steps towards protecting their citizens' privacy, because they recognize that this is an issue that people are talking about, and they need to do kind of that internal understanding of, okay, what are we actually offering, and what is the guidance that we should offer for the world in which we kind of have that jurisdiction.
I'll just say real quick, I mean, there is a Privacy Act, right? But it's from 1974.
Yes.
It's a little outdated, but it shows that there's an ability to come together and do legislation. I'll just say it's complicated. You know, that's the bottom line. And for me, again, I think it's important to distinguish, right? We say privacy, but a lot of what we've also talked about is data protection and security, right? And those things sometimes might conflict, sometimes they might, you know, align. And so being able to try to figure out how that applies across the board with so many different industries, technologies, it's just complicated.
I wanted to add two quick things to that. The first is a little bit snarky, which is, you know, it is Washington. People love power. And if there's a gap, a lot of folks, and just to keep in mind, right, I mean, agencies are not some box. They are people, you know, who run them. And people like to try to step in where that gap is and see if they can be the hero to solve whatever the problem is. That's number one. Number two, I think there's a distinction between, let's say, like an executive branch agency and independent agencies. And so my belief is that what some of those independent agencies fear more than the industry is Congress. And the FTC is a great example of that. This goes way back, but I don't know if it's something that might have prompted your question. You know, a number of years, decades ago at this point, the FTC tried to do some fairly aggressive regulation relating to kids. And the result was that Congress, you know, slashed the staff of the agency. So folks do tread, you know, somewhat carefully there in order to be sure that they can continue to do, you know, the work that they're charged to do. Charlie, I want to ask you, I see there's another question. We also did want to sort of finish on a career type note, but I want to keep you on time. So you tell me what you'd like us to do.
First off, my kids would get on me because I always make them introduce myself. And I failed. Charlie Bingham, Splunk Senior Legal Counsel, Partners and Strategic Alliances, and the founder of the Tech Law Summit. This is where we call our first audible, and I asked Devin, and it depends on you all. You'll get a great chance. They have lunch out there. If you were here in the beginning, so our keynote speaker, which was going to be a big deal and a surprise, is the National Cybersecurity Director. All of this stuff that we're talking about, she's coming to talk to you. But today, Biden decided that they're going to announce some national cybersecurity strategy. We will see what that is, which involves her and takes her away. And again, a day in the life of an IP and tech lawyer, you have to be able to adapt. So what we will do is you can continue these questions. Anup, I don't know if you can stay online with us for a couple more minutes if you need to go. We respect
I'm
that.
good. Yeah, I'm good to stay.
You're
Yeah.
good. And what I want to do is, you've heard from Julian, because I feel the bias here. I agree with you, Adonne, that America is behind. I used to be a public sector lawyer only. So part of public sector when you're doing government contracting is the US wants their data to stay right here, and we don't want to go anywhere else. And so GDPR doesn't come up a lot when you're dealing with some of these agencies. And I had to raise my hand and say, because GDPR was the hot thing, hey, I want to do something international then, because I need some GDPR experience. That's how I got into dealing with partners. And when you get out there internationally, yeah, America's like way behind. You got some insight with the cybersecurity, but I want us to balance this out. So you heard from the commercial people at Uber. Now we got the policy government worker. And now I just want to see, let's have a lively debate as they prepare the lunches, and you guys get a chance to ask more questions, and we could talk about whatever issue. So Devin, you want to come up? Julian? Would you like to join us?
Why
And
not?
you,
It's fun.
until you need, if you need to go, then you're welcome to leave, but ask away, especially the Howard students. This is your chance to find out what is it like, and you have the different perspectives, because we need diversity in everyone. If you need to go,
I'll go around.
you know, I know you got important stuff. Y'all just get up and go, and we'll fill in, and we're gonna have lunches out. I'll kind of wave you guys down and flag when we need to stop for lunches. We got a question. You all fire away.
Okay. Yes. Hi, Asia, Howard University School of Law again. Just out of curiosity, you mentioned like repackaging it, and I've noticed that like one of the things that I've been reading in one of my books for class is that part of what pushed Europe to make these privacy laws was this privacy concerns coming out of World War II, and it was a lot more a humanistic approach compared to the US, which seems to be very company-based and like kind of like tech-based. So I guess my question is, now that I'm seeing a lot of states like Utah and other states coming around and doing more like mental health angles to try to do legislation and privacy law and like children angles, are we seeing that as a potential repackaging where we're saying maybe we're not focusing so much on the monetary and the company piece of it, but maybe by looking at more human, concerns, more mental health, children, things that we can all kind of agree on that we should be moving in a certain direction? Would you consider that a repackaging to try to attempt to push some of these laws ahead?
That's good. So I think that's a great question. And it's great that you kind of see that playing out. I'd say I don't know if I like the word repackage.
Okay.
I'll say that I think it's not necessarily the full concept of repackaging. I think it's being able to still get at some of these privacy issues from different ways. So focusing on kids, for instance, or we've seen a lot of healthcare specific. And I don't know that it's a repackaging or a way to do this without necessarily doing the full thing, or excuse me, let me not say it that way. So essentially, I think the healthcare and for the kids, what we're seeing is something needs to be done in those in that world, and for kids and for those who have sensitive health information and that sort of thing. And so some of these bills, and as we see here in Washington, Congress can take time to move things. So at states, they're kind of also still playing into what they know that they can get passed for those states. So some of it is kind of the politics in terms of what can get through and still get at some of the issues that we are really concerned about. You'll see, for instance, the state of Washington has a more comprehensive privacy bill, but they also have a health specific one. So it just kind of depends on the different states that are trying to kind of get at some of these different issues. At even the federal level, we see different introductions of bills that are specific to those issues. And I don't think that's necessarily a packaging or a stand-in. I think we're just seeing, let's have comprehensive bills that get at these specific issues at the same time and potentially try to pass the comprehensive privacy legislation.
I might add to that, if it's all right. I hate to continue to be the cynic here.
The truth teller.
All right, I'm the truth teller. I like that.
Yeah.
But I mean, I think you have to look at the party politics of it as well, right? Like, when do things happen and start to move in Congress when things are very closely divided, when there's some agreement, right, across parties. And your point about industry was so well taken, right? Because I think if you back up 5, 10, 15 years, you see that people who are more politically conservative in Congress are listening to an industry at the time that said, don't regulate, don't regulate, don't regulate. We're in a really different place right now, which is a combination of industry, frankly, in a lot of places saying, you know what, a little bit of regulation wouldn't hurt here because we don't want to actually comply with 50 different state laws. And they might argue about preemption and things like that, right? But in general, the idea of having some clear rules of the road is not as unappealing as it once was. And then following that lead, you have Republicans more likely to say, all right, if it's narrow enough, we could see a benefit of some comprehensive legislation here. And then you also have that I think just people generally are experiencing tech in a really different way than they have been. And these privacy issues are kind of hitting everybody, whereas maybe, a decade ago, you were only hearing on the left that they were concerned. So I think it's a combination of those things too. Does that sound right?
Yes, it absolutely sounds.
I think to me, it's funny. So, whether you go to church or not is another point. But when I'm at church and I'm there, and then sometimes at the end they'll make you close your eyes and they'll say, raise your hand about whatever the issue is. And if everybody has their eyes closed, then folks are a little bit more honest about their positions and a little bit less afraid to raise their hand when it's applicable because the world's not watching. And I just feel like in this hyper partisan environment now, I'm sure that there are folks who, if you ask behind closed doors or with their eyes closed, if there are fundamental aspects related to privacy that everyone agrees to generally across the board, there's a lot, but it's just hard in real politics in this hyper partisan environment to get those same folks to raise their hands when everybody's eyes are open. And I just don't know when or if that will change.
It's quite sad, but she said, and I agree with the correction of kind of repackaging. There's different angles to this that the one role that we're missing right now is a lobbyist. And it'd be interesting to ask a lobbyist how they would handle this. But you brought up two ways. So like, how can we convince you, Congress, to act right? And one, we're behind. Whether we want to admit it or not, GDPR, it's a shame that we would have to kind of repackage it and say, well, this isn't really us following someone else. This is us being the leader somehow, even though we know that it's based on GDPR. That just shows you, as Julian said, what this hyper-partisan environment has done. We can't really have progress on a very important issue that, it affects mental health, and we just went through a pandemic, and it also affects children as well. And I get it. What is it? The Privacy Act 19? Like, yeah, that was different times. Now our Congress, we can't do things, and it also impacts the technology because again, this I want you to remember this theme of getting comfortable dealing with uncertainty. If you're trying to develop technology, you got to bob and weave right now because you're not sure what's going to come out in these different state laws. Without this national law or national platform, really what you have to rely on is, okay, does it comply with GDPR? That's fine. But what are some of the other issues? And Kevin, you patent? Yeah. I mean, you really are bobbing and weaving until there's some type of law there. But if you're in the development stage, you have a startup, and I'm thinking we just lost the Uber people. They had to go back to work. But Uber is a great example. It's where, all right, until they get their act together, we're going to go forward with our business and we'll ask for forgiveness later instead of dealing with the regulators on the front end. Like, business has got to go. Once we get big enough, maybe we'll go back to the regulators. But they made a calculated business decision of, do we deal with them now or should we just keep going, and when we're big enough, then we'll try to settle those issues.
Charlie, I was thinking earlier on the sort of career aspect of this that you're touching on there, that 20 years ago, or 24, if I'm honest, when I started practicing law, like privacy law wasn't a thing and a privacy lawyer wasn't a thing. And then I started thinking, all right, so 20-ish, years from now, what are people going to be that isn't a thing today? Right. So it isn't just the business models that are developing, but it's the legal counsel that needs to go along with it and the policy advocacy that goes with it. And what kinds of cool things are people going to be working on that we can't even fathom today?
It goes to the point we talked about, preparing for this. We talked about how we're at the almost quarter of this century, and so what does that mean? Like, what, when this century began, we were in law school 9/11, right? And you're talking about a completely, different conversation people are having now about security and what it means, right? In 2001, it was about terrorism. and those aspects. So these things happen in your lifetime. Most people are not aware it's happened. And then, then the issues in front of them, right? So, but it just didn't happen overnight. It's happened years in the making.
And I'm sorry, no, no, let's see,
And going to years in the making, as someone that lived in Europe for several years, we give credit to GDPR, but no one goes to the background, how many years it took to get that legislation passed and how they fight like cats and dogs between the countries to get their piece. And it's just the willingness to work through it that they were able to achieve, that regulation and the actual, robustness that was necessary to protect citizens throughout Europe.
I was just gonna add, I think this is obviously just my opinion, but I think it's gonna take, you mentioned 9/11, and certainly not wishing for 9/11 or some cataclysmic event like that. I used to work for the Defense Intelligence Agency. I was an intel officer back then doing counter intel stuff in those days. So I remember it well, but I do think it will take a substantial event that affects society before we move past this hyperpartisan stage. And it doesn't have to be terrorism or related. It could be the next advance in technology, right? Maybe it's something to do with Elon Musk and travel to Mars, or something that just changes like the current equation, because I just don't see anything changed until something big like that happens.
So I have two questions. The first one is, you mentioned COBA and the Child Online Protection Act, I think that's what it's called, earlier. One, do you think that is a good model for a cybersecurity law that can extend to people older than 18? And then secondly, kind of on the aspect of protecting just people in general. I'm sorry, I'm lost on my thought process. But what beyond hyper partisanship and what's happening in Congress, something that happened that I was privy to, like when I was in Georgia. I'm from Georgia, and during COVID, the big the breach with the gas stations, and we lost all that gas, and we couldn't get gas because of someone had hacked something. I can't remember what exactly it was called. Is that not something that would move Congress more, or did it take something that's on that level a bit larger to make Congress just say, okay, let's stop and let's move forward and make a comprehensive law? Because to me, that affected my life pretty substantially. I couldn't get gas for, like 2 or 3 weeks. But like, what is it gonna kind of take if we don't, of course we don't want a 9/11 type of event or a major cataclysmic event, but it kind of seems like it's going to take that to get a major comprehensive without someone having like a trifecta in Congress or in the branches.
Let me summarize your questions. The first one is COPPA, Children Online Protection Act. Do we think that's good for 18 and above? That's the first one. And then the second one is the Georgia incident. Is that cataclysmic enough? And clearly it wasn't. But we'll address COPPA first, and then we can all sound off on what we think it will take to get Congress there. And I'll go to lunch, but I'll have an opinion as well.
Sure. In terms of COPPA, I'm not an expert, and I do not purport to be one. That is not, children's privacy is not an area that I have spent an extensive amount of time. What I will say is COPPA does have pieces of it that are useful for protecting children online, because that was the context, and protecting kind of their data and different mechanisms for different agencies to kind of have enforcement abilities in certain circumstances for children's data. And so it provides some baseline kind of protections. I think one of the things about COPPA and similarly the Privacy Act of 1970 and communications, the Section 230 of the Communications Decency Act, they were done before we are looking at the internet and the concept of technology as we see it today. And so one of the things that I think is a constant conversation in the legislative world about how do we best do this. And I think Natalie, you mentioned, what do we do next, or what's coming next? And I think the last panel also kind of had a few points on how do we look forward to the future, and what do we do thinking about where technology is going to be. And so some of those conversations are how we have to look at legislation. So trying to even craft the necessary legislation to potentially work well 10 years from now is also one of the things that causes it to be complicated and causes it to kind of take a while. To the event that would need to occur, I do not know. We got really, really close for the first time in many, many years with ADPA, and unfortunately it stalled. And while I am an optimist in this small regard of holding out hope that maybe, just maybe, it would go through, it's still the bipartisan, it's a bipartisan bill, which is wonderful, but you're still gonna play some of those the politic games and seeing where both sides fall. So especially now with the changes, leadership in Congress, it's always gonna kind of come down to some of the politics of it. So the event necessary, I'm not sure. I wish there was a way to do it without having a major horrific event or cataclysmic event. But yeah.
No, I feel like that sounded doom and gloom. That's why I
It
meant
did,
no,
but-
but I meant, societal change, and I just want to reiterate that it can be a happy thing, right? It's just a major shift that I'm gonna focus on business. It could be business related, major shift. I use space as an example, but that's a real thing now we all know that's happening, and that will be a real thing. Space travel in the future and all that. Just think about all the like all the changes that came from the space program before, and think about now all the new technologies that's going to be developed, and new policies and laws that have to be passed related to that. So it can be a good societal shift. So that'd be an
I think the incident you were referring to was the Colonial Pipeline.
Yes.
And actually, Congress did pass a statute. It's the cyber, what is it here? The Cyber Incident Reporting for Critical Infrastructure Act, which the president signed last year. And that requires, incident reporting for critical infrastructure, and also is going to start requiring ransomware reports, disclosures within 24 hours. So, in response to that, Congress did get, but that's a very narrow, specific issue, right? I'll give you an example in my experience where I've seen a change happen, and take it back to the national security space in an area that a lot of people are not familiar with: submarine subsea cables, right? 99% of the traffic around the world travels through subsea cables around the world, right? And we were tasked with assessing those applications for applications by major companies to want to connect cables to the United States with other countries. And the reason that's happening, originally it started out with telcos, so that they could carry voice and data. But now you've seen more of what I've said, the hyperscale companies, right? Because they're connecting data centers globally. And those data centers are what AI, machine learning, cloud computing is going to run on, right? And so that infrastructure of submarine subsea cables, which many people don't even know about, became a very important issue in most recent years, including whether or not they should be connected to certain countries that may be considered foreign adversaries who want access to certain information. That was a space where 10, 15 years ago, you could connect your cables wherever you wanted to. But there was bipartisanship about the threats perceived with regards to allowing connections between the US and other countries for that amount of data to travel back and forth, to have for potential foreign adversaries to have access to, where there was bipartisanship, on that issue, and people came together. So I've seen it in very specific instances. But when you're talking about something big as legislation to touch on privacy, again, I'll go back to it's complicated.
I want to jump in there because this is why diversity is needed. I've been in the rooms where they've had these conversations with these submarine sub cables for data centers, And I remember very distinctly, because you're right, it's an issue of, well, we don't want to connect to this country, or we don't want to build a data center here. And my thought is, well, why? And ultimately, what it came down to, there was nothing in writing. And maybe I'm biased, but I try to be a truth teller. Some of the countries that they were prohibiting connecting to or building data centers, when you get down to the nitty gritty, because again, this is why diversity is needed. Why? Why don't you like this country? Well, human rights violations. Well, how is that different than what we do here? Let's get down a little bit more. And ultimately, it comes down to someone's decision. This is what I got in your biases, because it's all about perspective. If you think China or some of the African countries are doing something wrong as far as human rights violations, well, as an African American man here, I can look at what you're pointing there and say, well, you got three fingers pointing right back at you, US. So that can't be the reason why. Because I'm just as suspicious about our government using our technology to spy. Think COINTELPRO. We've talked about this at previous summits, as you are about this. Well, Gaddafi. I don't want to name anybody, but you think about maybe one of these Middle Eastern countries. So this is why we have this forum, because as he said, and I think Julian has been involved in some of these discussions, or are advocating for clients on the outside. But I've actually been in the room where we're making decisions about where we're going to build data centers, and I'm asking the questions of, well, why?
But I think that your point about being in the room, I think that is the biggest takeaway. And I tell people, to be in the room where it happens, you actually have to know the room exists, right? And these conversations that happen, I'm familiar with these conversations from the government side, although, I've engaged with companies as, we try to understand their technology and their business methodology and why they want to do certain things against, assessing that for risk from a national security law enforcement perspective. Having someone, having diversity in that room is critical, right? Because that's where decisions are made. And I can tell you, as someone who's been in those interagency meetings, there's not a lot of representation, and that's on the government side. So these policies are made beginning at the staff level. These are career people that work at different agencies that come together and talk about, well, this is what my leadership is interested in. Well, this is what my leadership's interested in. This is our equity. Those things get hashed out at the staff level, and then recommendations go up to leadership, right? And having diverse thoughts, experience, I think is critical, and it's definitely a vulnerability that exists.
And I'll just add, it's not. I'm gonna echo you now. It's complicated, right? Because you've got the national security aspect of those decisions, even when it comes to just internet access, like dropping the cables and who gets to connect. And again, I've got a national security background too, so I get it from that perspective. But then you kind of got the human rights aspect too, right? It's a counter question would be: do you deny an entire country who's at a different place in its development than the US the opportunity to expand that access to the internet provides, just because a few rotten apples who are in leadership have done the wrong thing? And so, trying to balance those real world national security threats with those real world humanitarian issues, it's just not an easy thing.
And the last thing I'll say on this is this is where understanding the business, like, so I think what I saw is there's a gap between companies' ability to explain how something the government is doing may put them at a competitive disadvantage with, their counterparts in other countries, right? Their ability to explain their technology and why this action you're going to take impacts us. Because the government doesn't necessarily understand the technology and how it works per se, right? At the level that the company that created it or administers it does. And then the other part of the gap is the government has access to information that the company doesn't, right? And has, you know, information at classified levels that it's making its determination on. So how do you bridge that? How do you bridge understanding the business model, the technology with the risk, so that you can get to a part where is the risk even appropriate, right? Are you concerned about the right thing, government, now that you understand this company's business model and technology?
Loyaan, I want to add to that for a second. Charlie, you said we were missing a lobbyist. I will confess to be a recovering lowercase L lobbyist, so
Okay.
not before Congress very frequently, but before government agencies
Mhm.
frequently before my current position. And I think, Loyaan, one of the things that you touched on is, for me, my experience is you go in sometimes to these rooms representing somebody in the private sector, you try to make a pitch to the government, you say, well, this will be the impact to our company. And the answer is, we don't care, because that isn't what we are charged with doing. So one of the things that, I've always tried to convey, whether it's when I'm training young associates or teaching law students, is that part of the job is matching up a company's or client's priorities with a public policy priority of the person who's making the decision, right? So if I'm going in to talk to Chairwoman Rosenworcel, I got a lot of buzzwords on my Rosenworcel bingo card that I'm going to use when I'm talking about what my client wants to achieve, right? What I'm not going to do is go in and say, it's really bad for my company that you're doing this, so don't do the thing. She's going to look at me, and Narda's going to look at me and go, why would we care? Narda has looked at me and said, why would I care, right? Which is totally legitimate. That's what you're supposed to do in that role. So I think for folks who are thinking about being sort of advocacy policy lawyers, that's a piece to it. How are you going to marry those things together?
And do you know the other agencies that you can leverage to this agency that is against your position, right? So you may have this, this agency may say, this is against, national security or law enforcement, but commerce over there might say, well, let's revisit that. Right. And so do you know how to leverage that? Do you understand how the interagency works? And that's why part of me saying this is getting people in the pipeline to understand the different agencies, how they work, how they interact, because that's a skill that is going to pay dividends for you in the future.
Relationships.
Hi, I'm Anya from Howard. So to the point that you made about knowledge and education on the technologies, and also to your point that we are so far behind in the United States on a lot of regulations and so on and so forth, I wonder how we can require that Congress or any government agencies develop more knowledge, or even lawyers at our level develop more knowledge, because we're so focused on learning policy and learning law, but learning the actual technology and how it works is kind of pushed to the side. So I would love to hear your opinions on that.
Oh, I think I was actually at the Department of Interior when Obama was elected. And one of the things that he did was he released and allowed federal agencies to use, I want to say the internet, but social media. Like, because for most, let's say Facebook, Instagram, you got the terms of service that you automatically have to agree to. Well, federal agencies can't agree to that. They have certain laws. They can't agree to be bound by Oklahoma or California's laws. So they would need someone to negotiate those. But for a federal agency, if, let's say, for example, we're the DOD, and all of us are the DOD, none of them can have a DOD account unless the DOD head says, all right, let's negotiate some terms and we can do that. So I think we can get there, but you have to vote, because think about who's legislating right now. As she said, people want to hold on to power. So we have people that are still elected officials that have been there for quite a long time. I don't want to throw anybody under the bus, but I mean, the leader, you think he knows how to use Chat GPT or any of these? I mean, I hate to sound like a voting advocate, but directly to your question, from my opinion, we have to vote and get young leadership in there. And it kind of starts with this conference. as he said, we gotta diversify the pipeline. We need people who understand this stuff and who has a balance, because there's always this economic balance. Companies are about money, government more power, but to some extent, there's some money there too. We want power and money. And so it's always a balance when they're making these decisions. And so we need people with broad perspective, diverse perspective, diversity of thought, levels, policy, government, in-house law firm to help shape the laws.
This, I would, we're classmates, and this guy right here, Georgia Tech electrical engineer, I'm not gonna compete with him, right? Like that just wasn't my thing, right? So I think you have to have subject matter experts, right? That you can, speak with, communicate with, learn from, right? And I think the majority of lawyers is, how do you apply that very specific technical know-how to the policy or the law, right? And that's what you are as a lawyer, right? So if you're lucky enough to come with a very technical background, that's great. If you went to Georgia Tech, MIT, you got a degree in biomechanical, Howard, or Howard. You got a degree in biomechanical engineering or quantum physics, and then you decide you want to be a lawyer. I don't know why you do that, but you decide you wanted to be a lawyer. You know what I mean? Then you're great. But the average person who's a lawyer is probably not going to come from that technical background. So how do you learn to communicate with subject matter experts?
So it's probably not my role here to, pitch Georgetown in any way. So I'm doing this very softly.
No, you are a supporter. Go ahead.
Listen, I work for Perkins Cool. You are fully authorized to take all the time.
Look, we give you a pitch, Natalie. We appreciate you.
So we have a faculty member at Georgetown Law, Paul Ohm. Some of you may have read his work or seen him quoted. He writes a lot on privacy. He writes a lot on sort of the administrative state and governance of tech companies, things like that. And one thing that has been very important to him for quite some time is to have as many lawyers as possible in the tech space, in the tech policy space, have an actual understanding of the technology. So he teaches Python for lawyers. And I think the last number that he gave me was that at least 1/6 of Georgetown law graduates in any given year are graduating having taken that class. So, computer programming is not for everyone, but that is certainly an option, because your point is so well taken. How are you supposed to be good at the lawyering of it if you don't understand what lies beneath it? And that's one path. The other path is to find other people who take those classes and rely on them. I like that path.
And that comes from my litigation background, right? Like putting expert witnesses on the stand, and and then after the trial, I don't know anything they do. For that moment, you're an expert.
I ran into Paul yesterday when we were leaving, and he was telling me about his course. And so plus one to that, to the extent that you do have the capacity, and that is something, there's tons of free coding tools, tons of kind of ChatGPT is obviously an open resource. And there are lots of things that you can do to just kind of play around with it yourself. And even if you're not fully understanding, you're still putting yourself in a position to be able to ask more intelligent questions about the technology to those individuals who do that. And there's a lot of opportunity, and I think the context of you'll find it a lot in law, the context of those who are patent attorneys, who have some of that technical background and expertise in especially the engineering space. You'll find that they are really great resources for helping to understand this. So to the extent that you can even just look around your classmates, I know when I was at Howard, there was at least a handful of students that had kind of that background. And so working and talking with your classmates, a lot of them have a lot of understanding for these different kind of technical aspects, because of their training, but also because they probably have interests, just as you have interest, but maybe want some more kind of in-depth knowledge. So I would definitely look to those in your class when you're going to these different events. A lot of other law schools, so Georgetown, for instance, has a lot deeper curriculum in terms of kind of tech and law together. So when you're going to these events, you get the opportunity to meet with other law school students who are at Georgetown. Those are some of the most important connections that you can kind of make, because you're going to end up in a situation where you have a much deeper network to ask these questions. There's someone on staff at FPF who his background was in computer science, and then he did library sciences, and then he was in academia for years, and now he's in the policy space. I ask all of my technical questions to him because he spent so long working on it that, I mean, he is a resource as an individual. And I think just to the same vein, outside of the more technical side of things, one of the wonderful things Natalie and I talked about yesterday, actually, but also as she's done on this panel, is connect the dots for how you can enter and engage in the tech space and in the law space and in the policy space, and how each of these different things is not specifically, you know, working for a tech company directly. Even just on this panel, you've heard us talk about kind of what we've done and how we've navigated the space of getting where we're going. So having a broader understanding of what working in tech and working in law and tech means is very useful. So attending panels like this is a great kind of first step to deepening your understanding.
And super quickly, I am a poster person for no tech background, and now doing a ton of different types of tech deals. I was a government major undergrad. I went to Georgetown undergrad too. Woohoo! Double it. And so government, political science, worked for the government. And so when I started practicing, like I was just interested in tech generally. So I started doing M&A deals for some tech clients. And got familiar with tech companies that way, because you do due diligence related to M&A deals. A lot of it is like self-taught. If you're interested in a topic, you got to be willing to not only do like what I call your 9 to 5 job, which is more like, I know whatever time we actually get off in big law. You got to do that, and then be willing to do a little bit of extra to get up to speed on tech and IP if that's what you're interested in. And so like, as long as you're interested in the topic, that's not really hard. You'll have folks that you're working with. You'll learn on the job as you're doing deals in a given space. Like, cause again, I did a chip acquisition, like semiconductor and chip acquisition deal recently. I did a gaming deal, that's Xbox game deal that same week, and on and on. And the point is, if you're interested, it doesn't seem like work just to kind of get up to speed on it, if you get what I'm saying.
You got something there.
I guess as the sole tech person on there, there are organizations. So there are the AIPLA. They have student organizations, IPO. These all have conferences, especially that come to DC, where you can just sit in and, you know, they'll have, you know, AI for lawyers, or, you know, certain types of technologies. But also, I mean, it's not just you. It's even for a tech person, but it also the curiosity. So I'll be on TechCrunch, or I'll be on whatever tech website, and like, oh, this, you know, ChatGPT, what was this? Down the rabbit hole I go. And so as long as you have the curiosity and start to try to find those resources, you'll be okay, because then you'll be able to put those pieces together and find the right people that can give you the information.
And shameless plug, first off, you guys are here, but for those that are at Howard and what we're trying to do, we have a tech law policy class that was established as part of, thanks to Perkins Coie support, as a part of the initial tech law summit. So you'll learn about these issues. I think they're using the book Microsoft Tools and
Yeah, we're in
Weapons.
that class.
Yeah, it can be a tool or a weapon. Hopefully we can be in the room to help where it'll become a tool, but I want to